about Securicor, actually I will go back to it, is prior to that case, Justice Denning had introduced this idea in Obiter of a fundamental breach, that it was possible to have a fundamental breach as opposed to a standard breach. The other thing that Securicor is famous for, if you can be famous as a court case, is overturning that idea, getting rid of this idea of fundamental breach. It sort of was a little bit of a thing in the early 80s, but I don't think we need to worry about it terribly. So again, this slide just talks again about allocation of risk, and the scope of an exclusion clause ultimately needs to fit within the four corners of the contract. So much quieter. Who have I left? Who have I locked out? We'll see. So now let's just think back to statements that are made prior to a contract being entered into, and the process that we go through to work out which of those pre-contractual statements may or may not be terms of the agreement. So and this will be important as you're going into the exam in particular. So I just want to highlight that thinking about how you get from a negotiation into a contract is going to be a key element for the exam. So we think about these terms in these ways. So we've got express terms, things that people have said, representations that have been made, and processes for thinking about whether or not those statements form part of the agreement. We then identify statements that are made that are never going to be contractual. So in particular, opinions that are given and not meant to be promissory in particular, statements that are made during negotiations when it's clear that the end written agreement is going to supersede that. And of course, things like puffs or inducements. And then lastly, we need to think about statements that are a key element of a person's decision to enter into a contract, particularly if those statements might be misleading or deceptive. So I want to talk about this in the context of, the case I'm going to use is Nifsan and Buskey in particular. I'll get to that in a second. And Nifsan and Buskey is I use it because it's a good illustration. I don't believe it's actually in your textbook or anywhere. It's a pretty easy case to find. It's a Queensland Supreme Court case. I think it's a single judge from memory. But I think it illustrates the complexity with something that we think should be pretty straightforward. So pre-contractual statements, we're imagining situations now where we have got a written agreement. And leading up to the written agreement, people have made all sorts of statements to each other. So think about buying a house, for example. Before you sign the contract, you go in and you have a look at the house, usually. You look at the plans, you look at the website for the agent, or some houses these days have their own website, don't they? You go and poke around in the, oh my goodness. That's my cleaning lady, clearly ringing to say hello. She's been sick. I really hope she comes tomorrow. Anyway, I'm still not 100%. I can't multitask. So you go in, you have a look, you get this sense. You talk to the agent, you might talk to people who live in the area. There's all of these things that go into your decision-making process. Then you sign your contract. And it may or may not have something similar to this entire agreement clause. This agreement constitutes the entire agreement between the parties and supersedes and extinguishes all previous agreements, promises, assurances, warranties, representations, and understanding between the parties, whether written or oral, relating to the subject matter. So in other words, everything that's on this piece of paper is what's in our agreement. Anything that we said leading up to signing this document doesn't matter anymore, including the emails we exchanged, the conversations we had, the bits of paper, any plans, any agreements, anything like that. Each party acknowledges that, in entering into the agreement, it doesn't rely on and shall have no remedies in respect of any statement, representation, assurance or warranty, whether made innocently or negligently, that is not set out in this agreement. So if I've said, I live next door to a school, and I've said, it's great living next door to a school. Everybody loves living next door to a school. You get to play soccer every day because people throw their football over your fence and you can collect them. You never have to buy toys for your dog ever again. And if it turns out to be misleading because it turns out that they're actually the other shaped footballs that come over your fence, they can't sue me on that kind of clause. Each party agrees it'll have no claim for innocent or negligent misrepresentation or negligent misstatement based on any statement in this agreement. And then lastly, nothing in this clause shall limit or exclude any liability for fraud. The last part is very common because the court is anxious to see that you are just limiting your liability, that you are not creating an illusory promise or not using the terms of an agreement as a way of effectively getting out of ramping something up. So the other thing that we have sitting next to this, though, is Section 18 of the Australian Consumer Law. Now, Section 18 is the provision that effectively says thou shalt not mislead or deceive or do stuff that could be misleading or deceptive. Doesn't of itself create any damages or any right to claim damages. It just creates the cause of action. So there is a general proposition against being misleading or deceptive. Now, it's interesting if you go and look at words and phrases judiciously considered and try and work out how is misleading different from deceptive and does it matter? The short answer is no. It seems to be that deceptive is usually understood to have some sort of modicum of dishonesty associated with it, but the bar is misleading or deceptive. It doesn't actually matter whether you intended to mislead somebody, it's just whether or not it was misleading or deceptive, either of them, not both. It can be both, but either is enough. The second limb of the provision is it could be misleading or deceptive, that a reasonable person would have been or could have been misled or deceived. So it's a very broad prohibition, and I think they just didn't change the language because it has been litigated so often with the language that's there. But also the ACL says you cannot exclude it. So you cannot opt out of this obligation. And that's because the exclusion clause in a contract can't break the connection between the conduct that might have been misleading and deceptive and the contract that was induced by that contract. So if I mislead you into thinking that, you know, if you buy my pointer from me, that you will get an HD not just in this subject, but every subject that you ever do in any university ever again, and you've been misled by that, my disclaimer that you can't rely on anything I said about this pointer prior to you purchasing it, it would be unfair when it's the actual... I'm assuming you don't need my pointer, you just want the HDs, right? So an exclusion clause at common law cannot provide protection against fraud. So as a matter of common law, you can't excise out fraud, and the rule applies to both Section 18 of the ACL, and because the rule applies to Section 18 of the ACL, we can't exclude Section 18 of the ACL. Section 64 is the one that provides the term in any contract, including a collateral contract term, and the recording will be available tomorrow morning, but we spoke a bit about collateral contracts in the tute last night. So any term, including a term of a collateral contract, which attempts to exclude, restrict or modify the application of the relevant parts of the Australian Consumer Law will be void. So ultimately the law has evolved so that there is a strict construction a strict understanding of any terms that seek to exclude, restrict or modify the law in any way. And so those terms, anything that looks like it might even be trying to hint at excluding the operation of the Australian consumer law, where it would apply, will be a void term. So lots of words on those slides. I'm not going to try and stack you through the provisions here, but it's there for you if you need it. And again, probably more words on this slide as well. Ultimately, it's a broad provision. It's going to apply, and it is nigh on impossible to exclude the operation of these provisions. Stepping back a minute, when we're looking at the Australian consumer law, and we spoke about this in the class last week, the Australian consumer law requires us to work out who is a consumer and when does it apply. So the general catch-all, misleading and deceptive conduct prohibition, applies way more broadly. But the warranties, so the statutory, well, they're now statutory guarantees that are implied into all consumer contracts and now small business contracts, apply in a small business or a consumer context. So we then need to go back to the definition in the ACL to look at, well, what is a consumer contract and who is a consumer? So again, it's not a blanket thing to say that those consumer guarantees will apply in every contract. But the Section 18 is a more general prohibition, and it applies effectively in commercial dealings. So let me tell you about Nifsan and Buskey. So this is the estate where the Buskeys wanted to purchase a property in the Gold Coast. And so this is the estate that they were purchasing into. It had some river frontage. At the time that they were looking to purchase, it hadn't been built yet, so they were buying off the plan. And the one thing that came out in the evidence anyway that was really important to them is they wanted to have a really, really great uninterrupted view. They wanted to be able to see the water. They wanted the forest behind them. They wanted to be able to see what it all looked like. So the way that this development worked is that the developers owned a large package of land, and they were building sort of one building, one part of the development at a time. And they had, on site, they had engaged a real estate company who were acting as their sales agents. So the sales agents, I don't know, I imagine as they have a little house there, it's possibly made out of containers or something or other, and you can go inside and they've got a couple of different sort of display apartments all set up, the same sizing that so you get a sense of what it might look like if you lived in one of these apartments, and no doubt in the place where the laundry would be, you get to sit down and sign a contract. And so the Buskeys went in there and they really liked the way the apartment looked, but they weren't, they just wanted to make sure they had these uninterrupted views. So the sales agent took them up into the building next door to the one that they were looking at, up to the similar floor height from memory. The fifth floor, and I think they were buying on the sixth floor or something like that. So it was similar floor height. They went up into the newly constructed apartment, but one they couldn't buy. And effectively the sales agent is saying, well, the views will be like this, just 80 metres to the left or right. So they got to see what it would look like. So that was a representation that was made to them before they signed the contract. So then they went back down and they signed a contract to buy this piece of real estate. And as is the case with these, so they had a standard contract, and the front of the contract would have the details of who the vendor was and who the purchaser was and the address of the property, those essential terms that we talked about. And then there would be some special conditions in the contract as well. And the special conditions dealt with things like what colour bathroom tiles they had and whether or not they would bring their own curtains or what quality of carpets. And they sat there for a number of hours working out what the configuration of their apartment would be and all the rest of it. And then they sent their contract off to a lawyer to check it out. And the lawyer looked at it and it looked like a contract and it smelt like a contract and had all the special conditions that they would expect to see in a contract like that. But, it also had this clause. This is clause 10.6, which is called the entire contract no representation clause. This is taken directly from the judgment. It says the buyer, so the Buskeys, acknowledge and agree that no representation. Now notice this, representation here, and there's a couple of other words. It starts, we've got nouns that start with capital letters in the middle of sentences. There's no law that says you have to do it that way, and some people don't, but it's a pretty common convention amongst law firms that if you're going to use a term to mean the same thing over and over again in an agreement, then you have a list, a glossary or a list of defined terms. You usually find them at the very beginning or the very end of the document. They're usually presented alphabetically, and it'll say agreement means the agreement that the parties made as set out in this document. Seller means the person whose name is in item blah, 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 making you go somewhere else. Representation is likely to be defined to mean things that were said in the lead up to the signing of this contract, including any emails, any signs, any brochures, any sales material, anything like that. Again, it's just a convention of the way to do it. One of the reasons why we write contracts this way is there's a general rule of construction. Again, I like to avoid the Latin, but I can't here. It's called the Eusdem Generis rule. Eusdem is E-U-S-D-E-M, I think. Generis as in general, G-E-N-R-I-S, E-R-I-S. And that basically says that if you've got a list of things, and they're the same, it incorporates everything in that list. But if you've got something that's different, then you intend for it to be different. So when we use the same terms over and over and over again in an agreement, a court will assume that we always mean the same thing. But if we use something slightly different, then we'll expect that a court would expect us to mean something different. So if, for example, we talk about the carpet, the floor coverings, and then specifically about the carpets, then the rule would say that the statement about floor coverings would attach to any kind of floor covering in the house, but the warranty that relates to the carpet only relates to carpet. It's carved out as being separate. So it's those kind of construction rules. We don't have time to go into all of them. You will find them along your way. That mean that we do this defined term thing. So the buyers acknowledge and agree that no representations of the agent or the seller were supplied or made to the buyer with the intention or knowledge that it would be relied on. In other words, nothing that was said to you beforehand was expected to be relied on. You're expected to go and do your own due diligence. No representations have in fact been relied on. So the buyer's saying, I didn't rely on anything you said, I did my own due diligence. Before we entered into the contract, the buyer satisfied itself from independent inquiries as to the value of the property. The buyer has relied on his own judgment in purchasing the property on the terms contained in this contract. The terms, so in other words, hasn't relied on anything the agent has said. The terms of the contract and a disclosure document, separate statement, are the entire agreement between the buyer and the seller, even if other things were said in the lead up to them being signed. To the extent that, in fact, anything above isn't true and some representation was in fact made, then the terms in this contract supersede them. Without limitation, no representations have been given that the property is or will remain fit, suitable or adequate for any of the purposes the buyer wishes to use the property for. And then lastly, to the maximum extent permitted by law, all representations or provisions implied by law relating to fitness, suitability or adequacy of the property don't apply to this contract or the property. Now, I'm thinking that's a pretty good limitation clause, right? Okay? It's got a few grammatical errors in it, which I think it's amusing that the court finds one but doesn't find the other. But, you know, at the end of the day, it's a pretty broad statement. No, sorry, I thought I had more in there. I'm going to rely on my memory again. So, next thing that happened after they've signed this contract, a couple of weeks later, it turns out that right in front of the block of land where this property was that they were about to, or they'd started building by this stage, they started turning the soil to build another property right in front, which was going to block the Buskey's views and no doubt impact the value of that apartment. Now, it turns out that the sales agent had no idea that that was going to happen. In fact, the developer had gone to some lengths to make sure that the sales agents didn't know that they had sought planning approval for this additional building. It is unclear from the facts of the case whether the Buskey's lawyer picked that up in the searches that were made. But it certainly was never, the Buskeys never discussed their desires for the uninterrupted views with their lawyer. They did what many clients will do, which is threw the contract in front of the lawyer and said, is this okay? And again, agreement is a verb, not a, well, it is a noun, but when it comes to advising clients on contracts, one of our ethical duties is to try and find out as much as we can about what it is that the client thinks the contract does, what it is that they have actually agreed to do, because some of the smartest clients I've ever had will never read a document, and actually making sure that it fits with their understanding that the noun and the verb match can be quite a difficult thing to do. And whether or not the Buskeys sued their lawyer, I don't know, but they certainly decided that they would not pay the balance of the purchase price, and they sued to get their deposit back. So, what happened? Ultimately, the court found in favour of the Buskeys that this clause was not sufficient to protect the developer. A couple of reasons for that. Firstly, the act of showing them the uninterrupted views, of taking them up into that other house, was a representation that was misleading or deceptive. Now, it was certainly misleading in the sense that they were told, you will get this uninterrupted view. Whether it met the deceptive test, we don't know, but it doesn't matter because it's misleading or deceptive. Why I say might not have been deceptive is there's no indication at all that there was any dishonesty on the part of the sales agent. The sales agent is just trying to get the sale. Nor was there any evidence that the developer was trying to mislead people. They didn't know how that the sales agent were doing that. Their reasons for not telling the sales agents is clearly it costs a lot of money to build an apartment block, right? So you're building an apartment block, you want to have as many apartments pre-sold as you possibly can. So they release them in stages because they would rather have 90% of a building sold before they open another one, because otherwise they'll only sell the top floors or the whatever or the garden floors or whatever happens to be in vogue on a lot of buildings, and they won't be able to complete their economic progress. So so there wasn't any, well, there was some criticism of the way that the developer worked with the sales agent, but we're not talking about any particular dishonesty here. It was more bad management. But ultimately, because that statement or that representation, that taking them up onto the 5th floor and showing them the view was misleading, and because you cannot excise out Section 18 of the law, then everything in this provision was subject to thou shalt not, in selling Gold Coast apartments, be misleading or deceptive, or do things that might be misleading or deceptive. So, sorry, I headed the wrong way. So, what does this mean? As lawyers, it actually amps up our duty when our clients are signing contracts. And this is just one example. I just think it's a particularly good example because it's a particularly good clause. Like, I looked at it the first time and before I'd read it through, and I thought, oh, why, how did this even get to the Supreme Court? These guys have got this. That's better than clauses I'd put in my own agreements, for sure. And so, but it does tickle the rethink on, if we're going to have an entire agreement clause, which lawyers have relied on for a very long time, it's like, I don't care what you said or did beforehand, it's in the agreement, we're contained within the four corners of this agreement. It actually has upped our ethical duty to have a better understanding of what the whole of the deal is, and whether or not just written communications, but whether activities like taking somebody and showing them something or giving them a sample, if that can affect the way that the contract works. It also pushes back the obligation not to exaggerate or puff up the qualities of the goods or services that you are selling before you do so, because that can get caught up into the contract, and goes to things like making sure that it's not only the people who sign the contract, but their agents, so employees and others who are on the sales floor or who are selling as representatives, that they understand what their obligations are. So yeah, I thought that was an interesting case and I think it's worth having a look at. So let you do some thinking at the moment. I'm not going to put it into quiz mode for just one, but which of the following is untrue? Pre-contractual statements that is not reflected in the terms of a contract can nonetheless be misleading or deceptive, affecting the validity of a contract. Secondly, a term of a consumer contract that purports to exclude, restrict or modify any of the rights conferred by or liabilities imposed by the consumer guarantees, which has that effect, is void. Exclusion clauses continue to have an important role to play in consumer contracts in Australia, or in consumer contracts, even exception clauses that have been properly notified have become terms of the contract on their true construction or enforceable, may still be void and unenforceable. One of those is untrue, the others are good little reminders for you. Some of you have got the slides so you can see. Anyone want to have a hazard a guess? It's about, they don't have letters. Consumer contracts. Let me see, A, B, C, D. Just realise you've got the slide. I start so naively thinking, can't I just present to my slides? Can't I change the order as I go along? But no. Which is this one? Okay, so Campbell and Backoffice Investments. Good quote here, refers back to Butcher and McLaughlin Elder Realty, which is from memory in your casebook. Neither the inclusion of an entire agreement clause in an agreement or the inclusion of a provision expressly denying reliance on pre-contractual representations will necessarily prevent the provision of misleading information before a contract was made, constituting a contravention of the prohibition against misleading or deceptive conduct by which loss or damage was sustained. Whether conduct is misleading or deceptive is a question of fact to be decided by reference to all of the relevant circumstances of which the terms of the contract are but one. So the parole evidence rule, which again I spent quite a lot of time talking about last night, recording will be available tomorrow morning, again that exception, that bringing in evidence is broadening to include evidence of misleading or deceptive statements which may have induced the contract. Or when you think about it, bringing in evidence of statements that induce the contract in order to determine whether they're misleading or deceptive, which in turn then goes to that parole evidence rule. Okay, sorry, question?
I noticed that ruling was 2009. That's pre-ACR consumer law.
Yeah. So this one here is 2009, so it's referring to Section 52 of the Trade Practices Act. They're the same clause.
But that would be, that would actually, I mean, saying the same thing, that would be superseded now anyway by consumer law, which can't be written out anyway.
Yeah, but Section 52 couldn't be written out either. So that there's no substantial difference in the way that Section 52 and Section 18 operated, or the numbers are different, but the provisions that made it, that prevented excluding them are also different. And I think that's one of the reasons why the language has stayed the same, because there is such a huge body of case law on Section 52, its operation, and that you cannot exclude it. Do you have a question as well? You just had a curious look on your face. It's just your face. Curious face. Okay, so the last thing that I want to talk about are the unfair contract term provisions. I'm going to fly here, very, very wordy slides, but I just want to give you a high-level overview so we can continue on. So the unfair contract terms, the name is beautiful. You think, okay, great, we've spent all of this time looking at these terms that appear to be unfair on their face, and now we've got some legislation that says you can't do that anymore. Kind of, sort of, if only, but not really. So the underlying principle that contract law is about the making of private laws between consenting parties, there are a carve-out where there are certain types of provisions in a limited type of contract that, if they are unfair, will be taken out of the contract, so excised out. So the relevant provisions are in Part 2-3 of the ACL, and the type of contracts that they apply to are standard form contracts. So the kinds of contracts where it's a take it or leave it. So things like your utility, contract with your utility provider, your gas, electricity, your telephone, probably your house and content insurance, residential property insurance, your mortgage, although mortgage is a financial product, will be under similar provisions in the ASIC Act, I guess. So the Australian, or actually be the Consumer Credit Code. So basically the ACL, or these provisions in the ACL, apply to standard form business to consumer, B2C contracts for the acquisition of goods, services or interests in land for domestic use. And since 2016, so these provisions came in around 2010 initially, I think, maybe a little bit later than that. And then since November 2016, they've also applied to small businesses as well. So what do? Section 23 says that a standard form consumer contract must not contain terms that cause a significant imbalance in consumers' rights as compared to the business rights, are not reasonably necessary to protect the business's interests, and cause detriment. So it's a cumulative test. There needs to be a significant imbalance that is not reasonably necessary for the business and cause detriment. So we've looked at that kind of scenario today when we think about the car parking case, the one where the car was stolen, the Davis. So there's a significant imbalance in the rights, in the sense that there's a broad limitation clause, and so basically the owner of the vehicle is taking all of the risk in relation to the car. But the court effectively is saying that's actually a reasonably good allocation of risk, because either party could insure. It's up to the person who owns, it could be great value or small value, how do you know? So it makes sense at a business perspective. It's reasonable for the business to have this provision. And then the last thing, cause detriment to the consumer. Well, yes, detriment was caused to the consumer in that particular circumstance, but if he'd been insured, that's a reasonable way for him to deal with that. So now that that particular case wasn't dealt with by, these provisions were not in existence when that case came out, but I'm just using it as an example to apply how this, you might think, well, that's an unreasonable provision, but let's go through and see, does it meet that cumulative test? Standard form contracts, like I mentioned before, they're take it or leave it contracts, and you can't negotiate the terms. I think I possibly have this on a slide that's coming up, but while I think of it, I'll say it. The onus of proving that a contract is, whether or not it's standard form or not, will go to the company supplying the contract. So if I'm going to have a fight with Telstra about my phone contract, and I say that a provision in it falls within the scope of the unfair rules, the way that it'll work is I will just state that that's a standard form contract, and the onus will then be on Telstra to demonstrate that it's not a standard form contract, that in fact they've contracted with me on a unique basis. Well, why wouldn't you? And because they're the ones who are in the best position to say how many contracts they have and to point out how they vary or how they're different from themselves. Certain types of provisions will never be excluded in the unfair contract terms, even if they are in fact unfair. So, and basically the reasons for this are a little varied. So firstly, a term that defines what the subject matter of a consumer contract is can never be unfair. And that's because it's not the role of the legislation to say what you can and you can't contract about. Terms that set an upfront price payable under the contract, they will never fall within this. And why is that? Because consideration needs to be sufficient. It's not for the courts to judge on whether it is good or bad consideration, a good or bad price. So unfairness doesn't necessarily go to price. And then the terms that are required are expressly permitted by the law. So terms that relate to statutory guarantees, for example, they will never fall within the unfair regime. There's also some stuff which comes from the way that Parliament makes laws and the way that parties negotiate. So company constitutions, contracts that relate to shipping or to towage, doesn't matter, they can have unfair clauses in them, as far as this law is concerned anyway. And only the court can decide whether a particular term of a standard form consumer contract is or is not unfair. Oops, wrong way. It applies to small business, which I've mentioned before. I'm running out of time, so I'm going to get a little fast. So in a nutshell, if a term, within the circumstances that the law describes, is unfair, then that term will be void. Same rules apply as we looked at when we were looking at express terms at the very beginning and when we were looking at certainty. So we looked at severance. So if you can sever a term out and the remainder of the contract continues to make sense, then the rest of the contract will continue to bind the parties. The court needs to consider factors when determining whether a contract is a standard form contract and whether it is unfair or not, and there's a slide that tries to summarise those particular factors. The legislation gives us guidance. It doesn't actually prescribe anything, because whether or not something is unfair can be reasonably ascertained in a context. But it does give us some examples, and Section 25 sets those out. Ultimately, there's a three-pronged test which relates to the imbalance in the rights, the protection of legitimate interests and detriment, so which I've already summarised in just a moment ago, and we'll continue on. So, sorry, I want to remind myself what's on here. In order to be a consumer contract, it needs to be a contract under which an individual acquires goods, services or an interest in land for personal, domestic or household use or consumption. So again, it is important when we're using the statutes to go back to the definitions. Okay, so let's have a look at the test, the 3 parts. Significant imbalance. So it's a responsibility of the person bringing the action. Now that might be the ACCC or it might be a person who is a party to the contract. It's the person who is bringing the action. They're the ones who have the onus of establishing that on the balance of probabilities that there is a significant imbalance. Terms that are not transparent may still be fair. Just because you don't know why your telephone company or your utility provider needs to have that clause, that feels unfair to you. So let me give you an example. There may well be a clause in your contract under which you use your phone or your internet that says you have unlimited data. And then it'll say something like subject to reasonable use. And at some point they might just have the discretion in the document that says that they can limit your bandwidth at any time at their discretion. And that could be really, really inconvenient for you. You might have a really big eBay gambling porn day planned and suddenly everything is limited, there's no streaming, you can't even Skype your mum. So that feels unfair to you. You think there is a significant imbalance. They're off taking your money and you can't do the things you want to do on your computer. It's not transparent to you why they are limiting your data or why they have their right. Ultimately, you need to demonstrate on the balance of probabilities that it's unfair, but just because it's not transparent doesn't necessarily mean that it will be unfair. It's also important to note that there's no good faith element here. Nobody has to be acting in good or bad faith or otherwise. It's just a test as to whether there is a significant imbalance. And there are some examples. The test also needs to be not reasonably necessary to protect the legitimate interest of the advantaged parties. So the onus will then be on the provider or the person who has the benefit of the clause to demonstrate that it is within their legitimate interest. So there's a rebuttable presumption that the term is not reasonably necessary, and once the action is up, it is then up to your internet service provider, your electricity company, whoever it is who you're arguing with to prove that they reasonably necessarily need that term. An inadequate explanation of complex or onerous terms may suggest that it's not reasonably necessary, but won't necessarily do so, but it might suggest that. Lastly, the term, in order to be unfair, needs to meet all three of these tests. It needs to cause detriment if it were to be relied on. It might cause detriment. Likelihood of detriment is not enough. You need to be able to demonstrate that there would be a detriment, but the detriment doesn't necessarily need to be financial. Court can take into account things that it thinks are relevant and must at least consider the extent to which a term is or is not transparent. So what does transparency mean? Section 24(3) will tell you. You need to have all of the following. It needs to use plain language, needs to be legible, and that will go to things like font size and your ability to read it. It needs to be clearly presented and needs to be readily available to any party that is affected by the term. But it's only one factor. So this comes from the Office of Fair Trading and Foxton's 2009 decision. Just because a highly skilled lawyer can find or contrive some equivocation in a word, that does not make the language lacking in plainness or intelligibility. So I mentioned before that the Act contains some examples of unconscionable terms. So 14 examples are provided as guidance. So they include things like terms that permit a unilateral change by one party to the contract. So where this comes up often is things like franchise agreements. So if I pick a franchise, if I'm McDonald's and you are my McDonald's franchisees running your restaurants everywhere, and I suddenly see the light and decide we are now going to be a vegan-only business. Also gluten-free. Gluten-free, vegan-only McDonald's from this point onwards, and because I'm the franchisor, I can change the terms. So again, a unilateral term, I think you might be able to show some detriment to your business. Maybe the world will be a better place though. Can you see how that works? So we find that often. Other things with franchise contracts where it comes up often is they change the scope of the, you know, you had all of the northern suburbs as your territory and suddenly it's like 3 streets in Clifton Hill. 3 streets in Clifton Hill, you can make a little bit of money on vegan, gluten-free, let me tell you. Terms limiting the rights of parties to a consumer contract are often unfair. Terms which penalise a party for a breach or termination of the contract, yeah, you can withdraw at any time provided that you pay $1 million. Terms which permit the assignment. I know you're not laughing with me, you're laughing at me. It's okay. We're just all in week 11 and it's time to be done. Terms which permit the assignment of a contract to the detriment of other party without the other party's consent. So we talked a little bit recently about assignments and novations and how if I'm your McDonald's franchisor and you're my McDonald's franchisees and then I suddenly just pick up and sell the business to Pizza Hut. And so I've assigned the benefit of my contract, you get no say, you don't want to do that, maybe that's an impact. And the regulations can also prescribe examples. To my knowledge, they have not yet done so. Oops. Sorry, heading backwards today. I've already mentioned standard form contracts and the onus is on the party who is arguing that it's not a standard form contract to demonstrate that. We use an ordinary commercial meaning. The legislation is clear on that. There is no statutory definition. My very old dictionary there says a standard form contract is a contract that is not individually negotiated by the parties but contains the same terms for all transactions of that type. They're also referred to as contracts of adhesion. Ultimately, it's usually obvious. If it's a printed form, if it's a take it or leave it, if it's a tick box on a website, it's likely to be a standard form contract. And the same rules for reading standard form contracts apply as for any contract. So things like the Four Corners rule, the way that we work with limitation clauses, contra preferentum, etc., will work in that same way. I've mentioned the burden of proof. Ultimately, it moves depending on which point that we're talking about. So if you want to argue that it's not a standard form contract, then the company will argue that. There will be a rebuttable presumption that a term is unfair. Once you get to that point, again, the company, or not reasonably necessary, and the company will need to bring evidence as to why it is reasonably necessary. I'm going to finish with this slide, which just summarises the types of things that the court needs to consider, but they are all examples. There hasn't been a huge amount of legislation, huge amount of litigation on these provisions yet, largely because it's quite plain language, I think, and a number of, when I say there's no litigation, I think in the like in the VCAT and other tribunals, this legislation is coming out quite regularly, but we're not ending up with just the disputes of the kind that would bring it up before the High Court. I will look at the rest of the slides and see if there's anything else I really need to point out to you, but at the moment I think we're probably as good a stopping place as ever. Oh, Craig, you got a question?
So I like buying movies on Apple, and I'm wondering if I have a dispute with Apple that I've clicked here, is my agreement covered with Australian consumer law
because you're dealing with a foreign power that doesn't pay tax here. Yeah, just because they don't pay tax here doesn't mean that we won't extend our court to them. Similarly, Amazon and others. So what in effect that really means is quite difficult to ascertain. So the reach of the ACL is broad. If you have if any element of the contract is in Australia, so a party, and if the goods are being delivered in Australia, then the consumer law will apply. What that actually means in practice, particularly if you're like me and have a small Alibaba addiction. Any of you ever go to Alibaba? So good for just losing all credibility as an environmental citizen. In theory, if my fancy glow-in-the-dark USB sticks don't work, I can sue. I can use the mighty power of the ACCC. All right, Sunday night, same time, same place for a toot. We're getting into revision mode. And then next week, it will be 100% quiz and activities, other than me outlining for you what the exam might look like, and hopefully some general feedback on the most recent assignment. But I haven't marked enough of them yet to guarantee that, but it'll be close. Okay? Have a great week. Thank you for your patience. Oh, and actually, no, given I've done really bad jokes today, don't worry about the CES. No, you need to do the CES. I'm on the recording. See, listen, I'm on the recording saying do the course experience survey, please.
So before the exam...
Just let...